If you are a business owner in Alberta and you were operating during the pandemic, you may be eligible in a lawsuit. Now, news releasing today, this is a new bit of information that's coming out. There's a class action lawsuit that's being filed against the Alberta government in their implementation of these orders during the pandemic that we all saw. Now, many people lost their businesses. Many people that maintain their businesses around were hurt tremendously. And today, to talk about this, I have with me Eva Chipiuk and Jeff Rath. Thank you so much for joining. This is big news, a big lawsuit moving forward. How did this all get going from the first place? Jeff?
Well, this all came out of the Ingram case in the Alberta Court of King's Bench. We started acting for Rebecca Ingram in the fall of 2020 with regard to all of the ridiculous orders that were being issued by Dina Hinshaw, shuttering businesses, taking away people's livelihoods, all out of, people being afraid of a Chinese cold bug in effect, that, may have been serious, with regard to, people that were over the age of 75 and dying of 3 or 4 other things. But for healthy Albertans wanting to go about their day-to-day lives, COVID was never an issue that needed to concern us. And notwithstanding that, Dina Hinshaw issued a series of orders shutting down the businesses of healthy people, preventing them from providing service to healthy people. And then that was later modified to say, okay, well, you can only provide service to people that have some sort of vaccine passport, proving that they got injected with a shot that didn't stop people from spreading COVID or contracting COVID. Mm-hmm. So, all of those orders were found by the court to be ultra vires the province, or patently illegal and outside of the scope of the Alberta Public Health Act. And it's on that basis that we bring this class action lawsuit. So the lawsuit in effect says, okay, all of these orders were illegal. And because they were illegal, they either A, offended Section 1 of the Alberta Bill of Rights, or B, were promulgated negligently by the government of Alberta and Dina Hinshaw, in effect, engaging in the largest expropriation of private property in Alberta history under orders that were patently illegal. So if you go back and remember, in the wake of the Ingram decision, all of the people that were charged with Public Health Act offenses, pastors, guys like Chris Scott that were hauled away in handcuffs for daring to open his business in the face of an illegal order. Chris was hauled away in handcuffs and thrown in jail simply for trying to feed his family. People, churches were put in prison, fences were put up around churches, and pastors were being jailed because they dared to preach the word of God in the face of Dina Hinshaw, who just thought she was God, saying that they couldn't. All of those people, all of their charges had to be thrown out when the Court of King's Bench ruled that those orders were illegal. Because how can you prosecute somebody under an illegal order? Well, it's the same theory going forward on a civil basis. And that is, how can you not compensate people whose businesses were destroyed? I mean, people literally lost their lives. I mean, business owners were driven to suicide by Dina Hinshaw promulgating these orders. And when I asked her about it on cross-examination in the Ingram case, I asked her point blank if she knew how many Albertans committed suicide because of her orders. So her response was, "Oh, well, you wouldn't have to ask me. You can't ask me that. You got to ask the chief medical officer, the chief medical examiner." So then when I asked her, it's like, okay, but you're the chief medical officer of health. Did you ask the chief medical examiner how many people have died as a result of these orders of yours? No. So she didn't even bother to talk to the chief medical examiner when she was being told in correspondence and otherwise that people were committing suicide over the hardship that were created by these ridiculous orders. So, unfortunately, a lawsuit of this nature is never going to be able to give, people their parents back or restore, people to life. But as far as it goes, what we're hoping for, is a multi-billion-dollar settlement that would at least, put some of these businesses or put some of these people who had all of their personal savings destroyed by trying to keep their businesses afloat, businesses that have literally lost millions of dollars in revenue through these arbitrary orders that are still paying back, additional business loans and lines of credit that they were forced to take out to keep themselves operating in the face of these illegal orders. All of these people need to be compensated and taken out from underneath. the ongoing financial pressure and financial damage that was done to them under the guise of completely unlawful orders.
You're well prepared for this. You're answering a lot of the questions I wanted to ask as you're talking here. Now, Eva, a lot of people are excited to see you as a part of this. I've been following you for some time on social media and what you've been up to as a lawyer. Now, what can people do to get to be a part of this? Because this started in this is news to a lot of people, and I'm sure there's a lot of people out there that are affected by this. How can other people get involved?
So you could go to the website, arathancompany.com, and then you'll get information about the class action. But of a very important note, in Alberta, it's an opt-out province for class action. So what that means is that everybody in Alberta that is deemed part of this class, and we're not there yet. It hasn't gone to certification, so we could talk about that a little bit more. But any businesses that were affected are already in the class action. So in essence, we represent them right now, and then they have an opportunity to opt out of this class action
after certification.
I see.
Yeah.
Now, Jeff, I wanted to ask you, because a lot of people were given these CERBA loans by the government. Now, it's a federal issue, but these loans, they were given to them only because they were out of work. They were told to shut down their businesses. Would this be part of the settlement in this to pay back some of those loans for people?
In my view, the Alberta government should be repaying all of those CERBA loans on people's behalf. Because on what theory, and again, just from a fairness perspective, let's ignore for a minute the fact that the Court of King's Bench found what Dina Hinshaw and Jason Kenney did to be completely unlawful. Okay, let's ignore that for a second and just think about it from an equity perspective or a fairness perspective, right? So even if you accept that these things were done for a bona fide reason and were done really for the benefit of society as a whole, right? On what theory should society as a whole benefit from completely destroying the business interests and economic interests of a small segment of that society? Mm-hmm. So in effect, what Dina Hinshaw and Jason Kenney were doing was shifting the brunt of the pain of COVID onto independent businesses and business owners in Alberta, in effect forcing them to pay for public health measures that were being enacted by Dina Hinshaw. So all of these half-assed measures that were brought in, excuse my language, but these half-baked measures, let's say, that were brought in. I know for a fact from being involved in other litigation where we cross-examined, members of the Alberta government, that they deliberately underfunded businesses, and they knew that they weren't keeping businesses whole with the business supports that were being put in place. So maybe certain segments of the economy, like the landlord segment of the economy, might be kept whole because enough money to be provided, to pay rent. But then what about all of the other business losses, beyond that are required to keep a business going? And that's why so few businesses didn't survive. It's like Taves and his finance department had created their own, evil stress test on Alberta businesses, and the overwhelming attitude of the Kenney cocktail cabinet, as I call it, was that, if a business doesn't survive these restrictions, it wasn't much of a business anyway. Right?
That's awful.
So, and it was just disgusting what they did, because they knew they were hurting people. They knew they were killing businesses. They should have known they were killing people by putting them into that kind of stress. I mean, all the suicides that were driven by these orders, and it was done, completely without justification. So thankfully, we have a Court of King's Bench decision saying that these orders were patently unlawful. And our perspective is that liability flows from that. And I hope that everybody that listens to your podcast and watches this reaches out to their MLA, reaches out to Premier Smith, and asks them why the hell they're fighting certification and why they're planning on fighting this action, as opposed to rolling up their sleeves and finding a way to settle this court case and get money into the hands of Albertans who have suffered so much as soon as possible. I mean, I'm not even clear that at this point, I think that's a good question for Premier Smith as to whether or not she's even aware that the Alberta government is fighting certification and has indicated that they intend to defend this lawsuit. Because I'm sure that'll come as quite a bit of news to Premier Smith's constituents and all of the people that elected her leader on promises that she was going to seriously address all of the wrongs that were propagated against people in Alberta under these evil Dr. Hinshaw, Jason Kenney orders.
Well, that gets me into my next question, Eva. I'll ask you this. We've seen a lot of these lawsuits come and go over the years, and actually, I didn't know much about legal anything before getting into it and talking with all you fine people doing this great work out there, and how difficult it is. I mean, words like ultra varies and all this stuff, I don't know what this stuff means. So, and this is where I'm trying to translate this to people out there that are watching this. When it comes to a class action lawsuit or a civil lawsuit, you need to prove damages. Now, that's pretty obvious here in this case, but we've seen so many cases come to the court and get dismissed, or it didn't pan out. What are the chances of this one actually succeeding?
So to start with, a lot of the cases I think that we've been seeing over the last three years with COVID restrictions and things like that had to do with charter applications. And I don't really want to comment on all of those. But what's very different in this case is the Ingram decision that Jeff has been talking about. There was some talk about the constitutionality of those orders. Let's set that aside because that's not the issue. The big issue of what Justice Romaine in that case found is that the public health orders were not enacted legally. It was an administratively illegal thing to do, not criminally, but administratively, because they didn't have the authority to do it. So in my view, actually, I think that's more powerful because it's not whether or not it's constitutional. So it's similar. Now we've seen the federal court finding the same thing with the invocation of the Emergencies Act.
That's right.
So we don't have to debate whether it was in the public interest or not. We know that the government officials went outside of their authority, outside of their power, and as a result, harms were caused. And
I just want to jump in on that. It's, like the Latin ultra vires, right? Ultra just means outside of, vires means the law. So the ruling is that every order issued by Dina Hinshaw was outside of the law. Or if you wanted to look at, ultra as meaning really or a lot, I like to think of her orders as being really illegal. They weren't just really but anyway, that's my Latin translation. But anyway, because of that, the government of Alberta doesn't have much of a leg to stand on, by way of a defense, because the issue of liability really has already been determined. So any defenses they'd have under the Public Health Act, as an example, that were section 66.1, which I say should be repealed, but that's for another day, says that you can't sue government officials for anything that was done under the Public Health Act. Because, and believe me, we planned this from the outset of the Ingram case. We sought the ruling of ultra vires to get around section 66.1, which says you can't sue if something was done under the Public Health Act. So if something is ultra or outside of the law or the Public Health Act, that means by definition, none of these actions were taken under the Public Health Act and we're free to sue. And not only are we free to sue, I mean, what we have now is a situation where, and again, this goes to, negligence, but I mean, keep in mind, Dina Hinshaw, who kept saying that she was everybody's doctor, she was so incompetent as CMOH, she wasn't fired once, but fired twice, if you remember that, right? So she didn't even know, and when I say she's incompetent, she was so incompetent, she didn't even know what the scope of her authority was under the statute under which she was acting. So, that's something that everybody needs to take on board here from the standpoint of pure negligence. Dina Hinshaw didn't even understand that, her role was to make medical decisions, not to go into the Kenney cocktail cabinet with a drinks menu and say, okay, boys, you can choose from, virtually no restrictions to we're going to lock the entire province down completely. Which one are you going to pick? And they chose the one in the middle. Right? So those weren't medical decisions. They were political decisions that Dina Hinshaw let them dress up as, public health orders. So that's what the court found to be, so problematic. We'd take it a step further. We would say that, there's a gross misinterpretation of the Public Health Act that anybody to think that Section 29 gave Dina Hinshaw the power to shut down the entire provincial economy, which is in effect what she did. Right? Section 29, on my reading of it, was like a typhoid Mary provision, where if you have one individual who's infected with a contagious disease that's intentionally going around society and giving it to people, that you can issue a public health order ordering them to be quarantined, or ordering you. And under the act, you can order a business to be shut down under Section 30, but under the act itself, if it's for more than 24 hours, you needed to go in front of a judge and get a judge to agree with you that that was a reasonable step. But they just went straight to this interpretation under Section 29 that literally said the chief medical officer of health could do anything to end the pandemic. So she literally could have expropriated every bank account in Alberta on the basis that, well, to end this pandemic, we need to institute $1 trillion research program, and we're going to develop our own our own remedies. And I heard that there might be some vaccine hiding under some green cheese on the moon, so we better start our own space program. There was no limitation on the words any any steps under Section 29 as far as the government was concerned. I mean, it's a ridiculous interpretation. Unfortunately, the court didn't go as far, didn't agree with us on that interpretation point, but they certainly agreed with us on the point that that all of the orders that were issued by Dina Hinshaw were outside of the scope of the Public Health Act and ultravirus.
And I like to thank all the business owners that actually stood up against the government, because they would have enacted further stricter rules had they not had some sort of fight back in this. And I want to thank you guys both and your law firm for bringing this court case forward and allowing people to get involved. This is really important for people moving forward. So Eva Chipiuk and Jeff Rath, thank you so much today for joining.
It was our pleasure. Thanks for having us. And again, if I could just make one last point, or maybe I've said it already, everybody needs to reach out to Premier Smith and reach out to their MLAs and demand answers as to why the government of Alberta appears intent on fighting this lawsuit. Because the orders were illegal, people were harmed as a result of illegal government action. And again, Danielle Smith can effect a twofer out of this by, settling this lawsuit, in the billions of dollars that are going to be required, and then withdraw that money from transfer payments to Quebec. I mean, we've already voted in a referendum that we should end transfer payments, and the government of Alberta can easily afford to settle this lawsuit on the level of magnitude that it requires. Mm-hmm. So just everybody would reach out to their MLAs and reach out to Premier Smith and demand answers as to why the government of Alberta is compounding the evil orders that were issued throughout the pandemic, destroying so many businesses and so many lives by continuing to fight this lawsuit.
Absolutely. Thank you for joining. And
thank you.
And for everybody out there, I'll leave the link in the description. You can go and you can sign up. If you are a business owner in Alberta and you have been affected by the pandemic and the measures that they put forward, please sign up for it. Again, link is in the description down below. Keep on trucking.
Thank you.